At 6:14 a.m., frost glazed the ditch beside County Road 450 North when a maintenance worker noticed a shoe half buried in frozen leaves. The air smelled of iron and pine. He stopped, listening to the quiet, realizing something final waited beneath the cold earth nearby. If you like stories like this, make sure to subscribe and like the video. Indiana in December had a way of going still. Cornfields slept under thin snow, two-lane highways emptied early, and courthouse lights burned late only when something had gone wrong. In the winter of 1992, the wrongness centered on a young woman named Melissa Anne Whitaker, 22 years old, last seen during the long holiday stretch between Thanksgiving and Christmas. She had grown up in the county, attended a local community college, worked part-time at a pharmacy near the square, and still lived close enough to hear the train horns at night. Her routines were ordinary, which is why the break in them stood out. Melissa vanished on December 3, 1992. She finished a late shift, locked the pharmacy door, and drove into the cold. Her car was found the next morning in a grocery store lot, keys missing, purse still inside. The lot lights hummed all night. No one reported a disturbance. Missing person flyers went up by the end of the week, taped to gas pumps and the courthouse bulletin board, their corners curling as snow fell. The local paper ran a short item on page 3. Police opened a file and began the slow work that defined small-town investigations: timelines, alibis, and patience. The discovery came 10 days later, during a routine inspection of drainage culverts along rural roads. The shoe led to a shallow embankment, shielded from view by sumac and frozen weeds. The body lay where winter had preserved details without drama. Investigators noted the position, the clothing, the lack of obvious disturbance in the surrounding soil. There was no spectacle, only the quiet weight of a young life interrupted. The coroner recorded time of death estimates consistent with early December. Hypothermia and blunt force trauma were considered. The autopsy would refine that assessment without sensational claims, noting injuries consistent with restraint and a cause that fit the scene. For men who had lived long enough to remember rotary phones and paper maps, the case felt familiar. It echoed other winters, other headlines, when communities learned how thin the line was between routine and tragedy. The sheriff's office worked methodically. They canvassed businesses near the grocery store, checked time cards, and pulled phone records. In 1992, DNA was not the tool it would become. Evidence was collected, bagged, logged, and stored in a cold archive room that smelled of cardboard and disinfectant. Fibers, a partial latent print, and trace material were documented. None spoke clearly enough to name a suspect. Witness interviews followed a pattern. Coworkers described Melissa as reliable. Friends noted she planned to attend a Christmas party the weekend after she disappeared. A neighbor recalled hearing a car accelerate late one night but could not place a date. An older clerk at the grocery store remembered a man loitering near the lot smoking, but the description was vague and inconsistent. Leads formed and collapsed. By New Year's Day, the town had returned to work. Decorations came down, and the case slid into the long middle where answers do not arrive. Media attention peaked and faded. The local press kept the tone restrained, reporting verified facts and urging anyone with information to call. A regional paper ran a longer piece before Christmas, noting the proximity to the holidays and the strain on the family. No rumors were printed. Law enforcement held to procedure, aware that missteps in small towns linger for decades. The years passed. Evidence boxes were moved from one shelf to another as offices were renovated. Deputies retired. A new generation took over. The file on Melissa Whitaker remained intact, thickened by handwritten notes and yellowing photographs. Each December, a brief mention appeared in the paper, a reminder that not everything had been resolved. For men who followed such cases, the pattern was recognizable. The early certainty that work would pay off, the long quiet, the risk of forgetting. In the late 2000s, change arrived quietly. The State Crime Lab expanded its cold case program, offering to review unsolved homicides for modern testing. Advances in DNA analysis meant trace evidence once considered insufficient could now be examined. The sheriff approved a submission. The process was slow, governed by budgets and protocols, but it moved forward. Fibers were re-evaluated. A degraded biological sample recovered from clothing was deemed viable. Results did not come with fanfare. A partial profile was developed and entered into national databases. It did not match any offender on file. Investigators did not announce anything. They waited. Months later, a familial hit suggested a possible line, not a name but a direction. Detectives began building quietly, re-interviewing people from 1992, comparing timelines that had once seemed fixed. One name surfaced repeatedly in old notes, a man who lived near the grocery store lot at the time, known for drifting between jobs. In 1992, he had provided an alibi that placed him at home, alone. No evidence contradicted it then. Now, records showed minor offenses in later years and a move out of state. Investigators followed paper trails, employment records, addresses, and a driver's license renewal that brought him back to Indiana. Surveillance was lawful and limited. When approached, he agreed to speak. The interview was procedural. No raised voices, no accusations. A voluntary DNA sample was requested and obtained under consent. Weeks later, the lab confirmed a match consistent with the evidence preserved since 1992. The probability figures were decisive. The file, once dormant, came alive with annotations and cross-references. Prosecutors reviewed the case, mindful of the age and the standard required. An arrest warrant was issued in November just before Thanksgiving. The timing mattered to no one involved, but the season sharpened the contrast. The arrest took place without incident. The community learned through a brief press release. Names were printed carefully. The courthouse filled quietly for the initial appearance, older men standing at the back, remembering the winter when it began. The case moved forward on records and facts. Defense motions were heard. Evidence custody was explained. The chain held. In court, the narrative remained restrained, focused on what could be proven. By the following spring, a plea was entered to avoid trial. The sentence reflected the gravity of the crime and the years that had passed. Afterward, the town did what it always did. Roads thawed, crops grew. The archive room kept its boxes, now marked closed. Each December, when lights went up around the square, there was a sense of something finished, not healed but accounted for. Melissa Whitaker's name was no longer only a question. For those who had followed from the beginning, that mattered. The months following the discovery settled into a familiar rhythm for investigators who had worked long enough to understand endurance. The Whitaker case moved from active urgency to sustained diligence, a shift marked not by neglect but by the grinding reality of finite leads. Detectives revisited Melissa Whitaker's final known movements repeatedly, pinning receipts, phone logs, and handwritten notes to a corkboard that never left the squad room. Her last paycheck was reviewed. The pharmacy security footage, grainy and incomplete, was copied and logged. Officers stood in the grocery store parking lot on winter evenings, observing how shadows pooled near the cart return and how traffic thinned after closing. They documented sightlines, distances, and timing, knowing that accuracy mattered even when answers did not appear. The coroner's report was reread with fresh eyes, emphasizing restraint, estimated timelines, and environmental exposure. Nothing suggested haste. Everything suggested deliberation. That understanding framed the case for years to come. It was not a crime of impulse, and that made it harder to solve. In small Indiana towns, people noticed patterns. The sheriff's office collected tips from neighbors who remembered vehicles idling or unfamiliar faces near the lot weeks earlier. Each tip was logged, assessed, and more often than not, closed without result. The process built a record that later generations would rely upon. Holidays came and went. Thanksgiving turkeys were carved. Christmas lights blinked against courthouse stone. Each season added another layer of distance between the town and the night Melissa did not come home. Yet the file remained active in spirit if not in staffing. It waited in the archive for a moment when method could meet opportunity and patience would finally matter. As years accumulated, the investigation matured into something quieter and more technical. The initial wave of interviews gave way to follow-ups spaced years apart, often prompted by nothing more than a hunch or a newly digitized record. Detectives compared the Whitaker file to other cases statewide, searching for similarities in location, timing, and victim profile. None aligned cleanly. Melissa was 22, cautious, local, and unremarkable in ways that should have protected her. That absence of pattern complicated every theory. The evidence inventory became a living document. Items once dismissed were reconsidered. Fibers collected from clothing were reclassified under updated standards. A partial latent print was photographed again, enhanced by software unavailable in 1992 and still failed to produce a match. The biological trace remained the most promising element, though technology lagged behind hope. Throughout the late 90s, the sheriff fielded calls from national tip lines and self-described psychics, all logged and set aside. The office resisted sensationalism, mindful of the harm it could do to a family already carrying loss. Local reporters maintained a measured tone, revisiting the case every December with restraint. They noted anniversaries and quoted official statements emphasizing persistence. For the men who read those pieces over morning coffee, the case represented a familiar truth. Some crimes require time as much as effort. The Whitaker file endured, not because it generated answers, but because it demanded accountability. By the early 2000s, institutional memory became a concern. Deputies who had walked the original scene retired, taking with them impressions not always captured on paper. To counter that loss, supervisors ordered a comprehensive review. The entire file was scanned, indexed, and cross-referenced. Photographs were labeled with GPS coordinates retroactively assigned. The ditch along County Road 450 North was revisited and measured again, its proximity to main roads and farm access points documented. Weather records from December 1992 were pulled, confirming freeze-thaw cycles consistent with the coroner's estimates. This attention to detail did not generate suspects, but it preserved integrity. When the state announced funding for cold case reviews, the Whitaker case was ready. Evidence was transferred under seal to the crime lab. The wait that followed tested patience. Months passed without updates. Investigators filled the time by recontacting Melissa's friends, now middle-aged, asking careful questions about routines and acquaintances. One remembered a brief relationship that ended months before her disappearance. Records showed the individual had been cleared early. Another recalled a coworker who quit suddenly. Employment files revealed nothing actionable. Each avenue closed quietly. Still, the renewed attention mattered. It signaled to the family and the town that the case had not been forgotten, only deferred until science could catch up. The lab results arrived without ceremony, delivered in a report thick with probabilities and caveats. A partial DNA profile had been developed from preserved material, enough to enter into national systems but not enough for a direct hit. Investigators understood what that meant. The work was not finished. It had simply changed shape. Familial searching, still controversial, offered a possibility, Approval was sought and granted. The profile suggested a male relative within a limited geographic range. Analysts generated a list of candidates based on age, proximity, and opportunity in 1992. Detectives returned to old addresses and utility records, reconstructing who lived where during that winter. One name, previously peripheral, surfaced again. He had lived within walking distance of the grocery store lot and had no verifiable alibi beyond his own statement. In 1992, that had been enough. Now it warranted scrutiny. Records showed minor offenses years later and employment gaps that coincided with holidays. None of it proved guilt. All of it justified attention. Investigators approached carefully, aware that time cuts both ways. Memories fade. Rights remain. The man had moved several times, eventually returning to Indiana. Surveillance confirmed routines consistent with someone unaware of renewed interest. When contacted, he agreed to cooperate. Consent forms were signed. A DNA sample was collected under protocol. The lab comparison took weeks. During that wait, investigators prepared, assembling corroboration and ensuring evidence chains were intact. They knew that resolution, if it came, would be measured not by emotion but by documentation. Confirmation arrived in late autumn, as fields turned brown and the air sharpened. The DNA comparison indicated a match within accepted forensic standards, supported by statistical weight that left little ambiguity. Investigators reviewed the finding with prosecutors, mindful of the burden of proof after decades. Additional evidence was assembled. Old witness statements were re-examined for consistency. Travel records placed the suspect near the grocery store on the night in question. Fiber analysis, revisited with modern techniques, showed compatibility between clothing items. None of these elements stood alone. Together they formed a lawful narrative. An arrest warrant was issued after review. Execution was planned to minimize disruption. The arrest occurred quietly, days before Thanksgiving, without resistance. The press release was factual and brief. The community reacted with subdued shock, a recognition rather than a revelation. Court proceedings followed standard timelines. Defense counsel challenged evidence handling. The state demonstrated continuity. After months of motions, a plea agreement was reached, acknowledging the strength of the case and sparing the family a trial. Sentencing reflected statutory guidelines and the seriousness of the offense. When the courthouse emptied that day, winter had returned. Decorations went up around the square. The case, once a question mark pinned to December, became a closed file. The town carried on, altered but steadied by the knowledge that patience, procedure, and time had finally converged. In the period between arrest and sentencing, the case file expanded in a way that only cold cases do, accumulating context rather than surprises. Prosecutors focused on ensuring that every procedural step taken since 1992 could withstand scrutiny. Evidence logs were audited line by line. Transfer forms from the early 90s were matched to modern inventory systems. The biological material that had carried the case forward was traced through each handoff, each freezer, each renovation of the sheriff's building. The aim was not to impress a jury, but to protect the truth from erosion. For men who had followed similar cases over decades, this stage was familiar and necessary. Justice, when delayed, demands precision. The defense examined the same history, probing for gaps created by time. Motions questioned memory reliability and chain of custody. The court answered with records and expert testimony grounded in policy rather than opinion. The narrative remained narrow. There were no dramatic revelations, only confirmations. Investigators reconstructed the timeline again, placing Melissa Whitaker's final movements against verified data. Weather logs showed a sudden temperature drop the night she disappeared, consistent with the condition of the scene. Traffic counts confirmed light activity near the grocery store lot after closing. Utility records placed the suspect's residence within a short walk. Phone records, limited by the era, still showed no activity contradicting the state's account. Each element reinforced the others. As winter approached, the family prepared for a resolution they had not expected to see. Their statements remained private, filtered through legal counsel and brief press acknowledgments. The local paper covered hearings with restraint, noting dates and outcomes without speculation. Older readers recognized the tone from other cases resolved late, when the work mattered more than the words. The courthouse itself became a quiet landmark again, its stone steps worn smooth by decades of routine. Inside, files moved from active carts to shelves labeled closed. The plea agreement, entered after consultation and review, acknowledged responsibility in a manner consistent with the evidence. It did not attempt to rewrite history or soften facts. Sentencing followed statutory guidelines in effect at the time of the offense, applied with modern understanding. The court considered aggravating and mitigating factors without theatrics. The final judgment was read into the record and recorded. The process concluded without applause or protest. Outside, the square prepared for the holidays, lights strung along familiar routes. The contrast was not lost on those present. In the weeks that followed, the sheriff's office conducted an internal review, not as a formality but as a learning exercise. The Whitaker case illustrated how evidence preservation and documentation could bridge generations of technology. Lessons were shared with neighboring jurisdictions. Policies were updated. Younger deputies learned why patience mattered and why accuracy, even when answers were absent, could later become decisive. The Cold Case Unit documented its methods, ensuring that future reviews would not depend on memory alone. The town absorbed the outcome in stages. Some residents remembered Melissa from school or work. Others knew her only from faded flyers and annual mentions. Closure did not erase loss, but it changed its shape. The case was no longer a question posed each December. It became a fact, integrated into local history with the same quiet acceptance given to other resolved tragedies. Media attention waned as expected. A final article summarized the investigation, emphasizing the role of modern forensic science and long-term diligence. It quoted official statements and avoided speculation. Readers clipped it or folded it into drawers, a habit formed over years of following local news. The story did not travel far beyond county lines. It did not need to. Its significance was local, measured in accountability rather than notoriety. For men in their 60s, the resolution carried a particular weight. Many had lived through the early days of the investigation, reading about it at kitchen tables, discussing it briefly at work, then setting it aside as life continued. The solution reaffirmed something they had learned before. Time does not guarantee answers, but it does not erase responsibility. The mechanisms of law, when maintained, can outlast individual careers and still function. The evidence itself returned to storage, now labeled with final disposition. Biological samples were retained according to statute. Physical items were documented for potential appeals, though none were anticipated. The archive room remained cold and orderly, its shelves bearing witness to other cases awaiting their own moments. The Whitaker file took its place among them, thicker now, complete. As the first snow fell after sentencing, the county settled into its routines. Roads were salted. Courthouse hours shortened for holidays. The memory of the case receded, not forgotten but no longer unresolved. The name Melissa Anne Whitaker appeared one last time in print as part of a year-end summary, then returned to the private spaces of family and record. In the end, the case offered no grand lessons, only a reaffirmation of process. A young woman lost her life in December 1992. The investigation did not end quickly or neatly. It persisted through seasons, technologies, and generations of officers. When resolution came, it did so through lawful means, grounded in evidence preserved with care. The community moved forward with that knowledge, carrying both the weight of what was lost and the steadiness of what was done. After sentencing, the case entered its longest quiet phase, one defined not by uncertainty but by documentation and permanence. Appeals deadlines passed without filings. Court clerks archived transcripts. The sheriff's office updated state and federal records to reflect final disposition. Each step followed protocol developed precisely for cases that had traveled far through time. The work was procedural and unremarkable, which was the point. When justice arrives late, it must arrive cleanly, without shortcuts or embellishment. The Whitaker case closed not with ceremony but with signatures, stamps, and entries in systems designed to outlast memory. The county prosecutor issued a brief year-end report noting the resolution among other routine matters. It emphasized evidentiary integrity and cooperation between agencies. There were no quotes from family members and no commentary on motive beyond what had been established in court. That restraint mirrored the approach taken throughout. For those who had watched the case unfold over decades, the absence of spectacle confirmed that the outcome belonged to the record, not the spotlight. The local press followed suit, printing a final summary that placed the arrest within the broader context of cold casework nationwide. The article ran just before Christmas, below stories about school closures and holiday traffic. Winter returned as it always did, bringing with it the familiar rituals that had framed the case since the beginning. Courthouse wreaths were hung. The square hosted a small tree lighting. Older residents walked past storefronts that had changed names but not addresses. The grocery store lot where Melissa Whitaker's car had been found still filled and emptied daily, its lights unchanged. Life continued in ways that felt both reassuring and indifferent. The case, once a source of seasonal unease, became part of the town's settled past. Within law enforcement, the resolution prompted reflection rather than celebration. Supervisors used the case in training sessions to illustrate evidence preservation and the value of thorough documentation. Recruits learned how notes taken without expectation of immediate payoff could later become decisive. The biological sample that ultimately identified the suspect existed because someone in 1992 followed procedure, even when technology offered no promise. That lesson resonated with officers who understood that most investigations do not announce their importance at the outset. The suspect began serving his sentence in a state facility, processed without incident. Intake records listed the offense date alongside the conviction year, a stark juxtaposition that underscored the passage of time. There were no public statements from him beyond what was entered into the plea. The system absorbed him as it does others, assigning numbers, routines, and schedules. The case ceased to be active in the minds of those tasked with its resolution, transitioning fully into history. For the Whitaker family, privacy remained paramount. Their interactions with the justice system concluded with final paperwork and a quiet acknowledgement of closure. The absence of public comment was consistent with their approach over the years. Loss did not require amplification. In a town accustomed to respecting boundaries, that choice was understood. Neighbors offered condolences without questions. The matter rested where it belonged. As spring followed winter, the county conducted its annual records purge, guided by retention schedules that distinguish between what must be kept and what may be released. The Whitaker file, classified as a solved homicide, remained intact, preserved for statutory periods and potential future review. Digital copies were backed up. Physical evidence was secured. The archive room maintained its careful order, shelves bearing labels that represented decades of work. The cold air in that space carried no drama, only the steady assurance of continuity. The case also influenced policy discussions beyond county lines. State meetings on cold case funding referenced the outcome as an example of return on investment. Grants were renewed. Lab capacity expanded incrementally. None of this traced directly back to Melissa Whitaker in public forums, but the connection was understood by those involved. Progress in one case often sustains many others. In conversations among residents, the case surfaced less frequently as time passed. When it did, it was recalled with the specificity reserved for resolved events. People remembered where they had been in 1992 and how old they were when they read the first article. They remembered the uncertainty and the annual reminders. Now, those memories carried an ending. The shift mattered, particularly to men who had lived through similar arcs before. Resolution did not restore what was lost, but it stabilized the narrative. The seasons continued their cycle. Thanksgiving arrived with its familiar rhythms. Christmas followed, marked by lights and early darkness. New Year's Eve passed quietly, without mention of the case. The absence of reminders signaled success. A story that no longer needed retelling had reached its conclusion. In professional circles, the Whitaker investigation became a case study referenced sparingly and accurately. It demonstrated how advances in forensic science intersect with disciplined record-keeping. It showed how restraint in media relations can preserve integrity. It underscored the importance of revisiting assumptions without abandoning standards. None of these points were dramatic, but all were essential. The road where Melissa was found remained a stretch of pavement bordered by fields. Maintenance crews continued their work each winter morning, scanning ditches for debris and damage. The moment that had begun the case was not reenacted or memorialized. It existed only in reports and memory, where it belonged. The land absorbed the passage of time without comment. By the following year, the case appeared only in archival searches and academic references. New crimes demanded attention. New files opened. The machinery of justice turned as it always had. The Whitaker file rested among others, its journey complete. In the end, the resolution affirmed a principle older than any technology involved. Care taken today can matter decades later. Procedure is not an obstacle to justice, but its foundation. Melissa Anne Whitaker's case did not become famous. It did not change laws or inspire books. It did something quieter and more enduring. It proved that persistence, restraint, and lawful method can survive time and still deliver answers. That knowledge settled into the community like winter itself, familiar and steady. The story ended not with relief but with acknowledgement. A young woman's life was taken in December 1992. The truth was established. The responsible party was held accountable. The town carried on, changed but intact, its history one case clearer. In the years after the file was marked closed, the county adjusted to the absence of a question it had carried for a generation. The Whitaker case no longer required periodic review meetings or anniversary press statements. Its presence shifted from active concern to settled record, a transition that altered the rhythm of institutional memory. Clerks who had once pulled the file every December now passed its shelf without pause. The archive room remained unchanged, its temperature regulated and its order intact, but one burden had lifted. The work had been completed as intended. The final audit confirmed that all statutory requirements had been met. Evidence retention schedules were observed. Notifications to state databases were verified. The conviction was entered into national systems, closing any remaining administrative loops. These tasks were not visible to the public, yet they represented the final steps of accountability. When justice is delayed, its completion must be thorough. Nothing in the Whitaker case was left provisional. Everything was fixed in place. Academic interest emerged briefly, limited to professional circles. A regional law enforcement journal summarized the investigation's trajectory, focusing on evidence preservation and the lawful application of evolving forensic science. The article avoided speculation and emphasized procedural continuity. It cited the case as an example of how disciplined record-keeping could bridge decades. The mention was factual and brief, consistent with the tone that had defined the case from the beginning. Outside those circles, the story remained local. For the town, memory settled into landmarks rather than dates. The pharmacy where Melissa worked closed years earlier, replaced by another business. The grocery store lot remained, repaved and restripped, its lights modernized but familiar. County Road 450 North continued to carry farm equipment and school buses, its ditches maintained without reference to the past. These places absorbed history without displaying it. Residents passed through them daily, aware only in passing of what had once occurred. The courthouse continued to anchor the square, its routines unchanged. New cases filled the docket, reflecting contemporary concerns. Judges rotated, attorneys came and went. The Whitaker case did not linger in conversation. It did not need to. Its resolution allowed it to recede, a mark of success rather than neglect. For those who had waited decades, silence signaled completion. Among retired deputies, the case surfaced occasionally in private recollections. They spoke not of frustration but of validation. Notes taken in 1992 had mattered. Procedures followed without expectation had borne fruit. The lesson reinforced their understanding of the profession. Law enforcement, when practiced with restraint and accuracy, can outlast individual careers and still function. That belief sustained them long after their active service ended. The suspect's incarceration progressed without incident. Annual reviews followed standard protocols. No appeals altered the outcome. The sentence stood as imposed, reflecting the seriousness of the offense and the evidence supporting it. The system did not revisit the case beyond required administrative checks. Stability replaced uncertainty. For the Whitaker family, the passage of time continued to reshape grief. Resolution did not erase loss, but it removed ambiguity. The absence of unanswered questions allowed memory to settle into something quieter. Their privacy remained respected, consistent with the community's values. The case belonged to records and history, not to ongoing discussion. Each December thereafter arrived without official comment. The local paper no longer ran anniversary pieces. The holidays reclaimed their ordinary meaning. Thanksgiving dinners were held. Christmas lights went up and came down. New Year's Eve passed without reflection on a crime long resolved. The calendar no longer carried that weight. In training rooms, the case became a reference point rather than a narrative. Instructors cited it to illustrate best practices, emphasizing that evidence collected without immediate promise could later prove decisive. Recruits learned that patience and documentation are not abstract ideals but practical tools. The Whitaker investigation served that purpose quietly, without embellishment. The broader community moved forward as communities do. Population shifted. Businesses changed. Schools updated their facilities. The case did not define the town, but it informed its understanding of diligence and restraint. Residents recognized that justice could be slow and still arrive intact. In state-level discussions about cold case funding, outcomes like Whitaker's supported continued investment. Budgets reflected cautious optimism grounded in results. Labs expanded incrementally. Policies evolved. The case contributed indirectly to those decisions, its influence embedded rather than advertised. Years later, a visitor searching county records could find the case summarized in public documents. The entries were concise, factual, and complete. They listed dates, charges, and disposition. They offered no narrative beyond what was necessary. That economy of language reflected respect for both the victim and the process. The land itself bore no marker. There was no memorial at the ditch, no plaque by the road. The absence was intentional. The case did not require a physical reminder. Its resolution lived in records and in the quiet assurance that the system had functioned as intended. For men who had followed the case from its beginning, the conclusion reaffirmed something fundamental. Justice is not measured by speed or spectacle. It is measured by accuracy, legality, and endurance. The Whitaker case embodied that measure. It did not rely on confession or coincidence. It rested on preserved evidence, careful review, and lawful procedure. As decades turned, the case faded from active memory. New stories replaced it. The town's history expanded, absorbing the event without centering on it. The Whitaker name remained in records and family memory, where it belonged. In the end, the story closed without flourish. A young woman's life was taken in Indiana during the winter of 1992. The investigation persisted through years of uncertainty. Evidence was preserved. Science advanced. The truth emerged. The responsible party was identified, charged, and convicted under the law. The community acknowledged the outcome and moved forward. That conclusion did not restore what was lost. It did something more modest and more enduring. It established facts, assigned responsibility, and allowed time to do what it does when questions are answered. The case ended as it began, quietly, grounded in procedure and restraint. The record remains, complete and settled, carrying forward a simple account of what happened and what was done.